My name is Quinn Johnson, and I am a student at the Indigenous Community Legal Clinic, located in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo Nations. Today, I will be going over the specifics of filling out the BC Human Rights Tribunal application form, known as the Individual Complaint Form 1.1. This video is part of the Lived Law Project series on the British Columbia Human Rights Tribunal. Step 1. Party information. Part A. Complainant contact information. The person who experienced the discrimination is called the complainant. The party who committed the alleged discrimination is called the respondent. 1. Who experienced the discrimination? Legal name. Fill in this section with the name that appears on your birth certificate. What your name is in the eyes of the law. For some folks, this may be a dead name. The tribunal, unfortunately, at this time does not effectively provide for trans protection in this manner. Preferred name. Fill in this section with any other name that you go by. You can specify in the box beneath when you want your preferred name utilized. Unfortunately, in all decisions, your legal name will appear, be it a dead name or otherwise. Title. Select the title you most identify with or write in your own. Pronoun. Select the pronouns you most identify with or write in your own. 2. Who will communicate with the tribunal about this complaint? If you are filing this complaint yourself, simply check the box labeled the complainant. You do not have to fill out your information a second time. 3. Complainant's address for delivery. The email, mailing address, and telephone number that you provide in this section will be made available to the respondent. The only information that you must provide is a mailing address. However, including an email will facilitate far simpler communication between yourself, the tribunal, and the respondent. The email and address you provide will be where documents related to your complaint are delivered. Once something is sent to these locations, such as notices, it will be considered received, and any limitation dates associated with responses may be initiated. Once something is sent to these locations, such as notices, it will be considered received, and any limitation dates associated with responses may be initiated. Part B. Respondent contact information. The respondent is simply who discriminated against you, be that an individual or an organization. Oftentimes, it may be an individual who discriminated against you. But if they are a representative of an organization at the time, be it a coworker, a landlord, or someone providing you a service, then the organization will usually be responsible for the action of the employee. The organization that the person represents should be named as Respondent Number 1. If Respondent 1 is a corporation, be sure you look up the formal legal name of that corporation so that you can properly enforce any orders against them later. Respondent Number 2. Respondent Number 2 should be the actual person who committed the discrimination if you are able to recall who that person is. If no one specific person discriminated against you, then naming the organization as Respondent 1 should be sufficient. An example of this might be in a workplace where a general culture of discrimination existed. The section where you name and provide information about the respondents may be difficult to fill out due to a lack of information, but it is important that you provide as much information as you can. If one of the respondents is an organization, it is best that you provide the information of someone who may have the authority to respond on behalf of the organization. This could be a human resources department or a legal department. But in a smaller organization, it could also be upper management or the owner of the business. Step 2. Area and grounds of discrimination. Part A. Area of discrimination. This part of the form is where you are going to indicate the context in which you were discriminated against. These are the categories that the Human Rights Code protects. What you experienced may not fit perfectly into one of these boxes, but you can simply select the box or boxes that you think are closest to what occurred. It does not have to be a perfect match, and you can select multiple if it fits into multiple areas. Part B. Grounds of discrimination. This section may seem complex at first, but it is actually relatively simple. Here is where you select the characteristics you have for which you were discriminated against. In some instances, this will be very clear, but in others, it may be that you have multiple traits which they may have discriminated against you for, and it isn't necessarily clear which it was or it may have been all of them. In this part of the form, include as many areas that may be relevant to what happened. For each one you include, you have to provide the details. If you are discriminated against for your race, include your racial identity. Some traits may overlap, for example. Discrimination based on race may also be discrimination based on color, ancestry, and possibly religion. Make sure you include all relevant areas. Make sure to review every form of discrimination and include all that are relevant to what you experienced. Step 3. Details of the discrimination. Part 1. Here, the form is asking you to describe the harm you experienced in a few words. Harm can be classified all sorts of ways: physical, emotional, and financial, for example. Feeling uncomfortable, unsafe, or humiliated are all harms. Losing out on a promotion, a job, or other financial opportunity is harm. Being fired for a reason connected to your protected trait or grounds is harm. When thinking about this part of the form, consider how the discrimination made you feel and what you may have lost as a result. Part 2. This part of the form is asking you to connect your protected grounds or trait that you described in Step 2, Part B, to the harm you experienced. This can be difficult to put into words, but it is important to draw the connection. This is the specific action or lack of action that has led you to experience the harms you described above. Lack of action includes situations where you should have been accommodated for, but were not. Read the examples provided on the form for some idea of how it is expected that you formulate the experience or experiences in this part. For this section, you can add up to 5 additional pages. If what you experienced was ongoing or you were discriminated against in a wide variety of ways, this is your opportunity to point all of that out. Respondent 1 and Respondent 2. These are the people or organizations that you listed in Step 1, Part B as Respondent 1 and possibly Respondent 2. Name them again on the lines provided. This area is for you to get into the specifics of what they did or didn't do that resulted in discrimination. If it is an organization, it may be that they failed to accommodate for your specific trait or grounds. What happened may be a series of incidents or just one. It is important that you list them all as best you can in order of occurrence. If one page is not enough, you can add up to 5 extra pages for each respondent. Step 4, time limit. Part A. Unfortunately, there is a time limit on when human rights complaint can be brought to the tribunal of 1 year. You have 1 year from the time you experience the discrimination to fill out and file this form. This part is trying to determine whether you have fallen within that time limit, and if not, if there's another arrangement that can be made. If what happened occurred entirely within the last year, you can fill out the first 3 points, and then you can skip to Step 5. If some of what happened occurred within the last year, or if even the last of a series of incidents happened within the last year, your complaint may still be eligible as long as the incident was part of a series of related incidents. Say a coworker used racial slurs towards you consistently for 4 years, but was fired 11 months ago. If the last incident of a coworker using racial slurs occurred within the last year, then you can connect that as part of a similar behavior that has been ongoing for the last 4 years, and all incidents may be considered in the complaint. If this is similar to your situation, answer yes to point 4 and fill in points 5 and 6 to the best of your ability. If not, answer no to point 4 and move on to Step 4, Part B. Point 5 is a bit of a gray area on the form. This means it is unclear on exactly what criteria the tribunal will decide that something is related enough to be considered a series of incidents. It is important that you make it as clear as possible to demonstrate how the incidents are related to each other. For the racial slurs example provided earlier, one could say that each event was about the use of racial slurs and that they happened in similar contexts. Indicate the things that were similar about each incident. Point 6 is for you to explain why there may have been gaps in time between the similar incidents you raised in point 5. In our racial slurs example, say the coworker was sent to work on a different schedule for a few months before returning, and therefore there was no incident for 3 months. That would explain the gap in incidents. Part B. This area of the form is to be filled out if either the entire series of incidents or part of a series of incidents happened more than 1 year ago. This is an opportunity to explain why your complaint should still be considered. This area of the application form is very unclear. There is no guarantee that the application will be accepted late, even if you provide evidence of why it was late or make a convincing public interest argument. For this whole section, you can add up to 5 additional pages, so you are not limited to the small space provided. For point 1A, to the best of your ability, provide reasons why you were unable to file the complaint on time. You can provide supporting evidence like doctor's notes to suggest that you may have been experiencing something that kept you from filing on time. There are a wide range of reasons you may have had to file late. You may very well just not have felt safe filing a complaint before. Whatever it was, provide the reasons that delayed you. For point 1B, in order to accept late applications, the tribunal requires that you demonstrate that advancing your case would result in a benefit to people at large. This area may be the most difficult to fill out, as it is not always immediately clear how your complaint can benefit the public at large. You may have a very unique situation that hasn't been heard before and would benefit the public awareness. You may have experienced harms that would be against the public interest and justice to ignore. Overall, this area demands some creativity, and try your best to find a way to make what you experienced important to be heard for the sake of society. The key to point 2 is that it is asking whether the application's lateness will cause harm, not that the application itself would cause harm. If you cannot identify any way in which accepting the late application would harm anyone involved, including the respondents, then you can write exactly that. Step 5, Other Proceedings. This section is only for those who have other ongoing legal proceedings related to the same event and want to put their complaints on hold until those other proceedings are completed. If you do not have another proceeding, simply check no in part 1 and skip to step 6. For those that this is relevant to, please consult with who is representing you in the other proceeding for help with this section. When I say a legal proceeding, I mean any other legal process that you may have started related to this event. Step 6, Remedies. This section is where you indicate what you are hoping to get out of filing this complaint. There may be multiple things, so check all that apply and add specifics as necessary. Think about what you really want from this process when filling out this section. Remember that the tribunal is designed to provide you with a more flexible remedy than a court could. That means that you can request something more than just compensation, including an apology or a requirement that the respondent attend some type of sensitivity training, for example. Step 7, Mediation. Read over the information provided on the form and consider if that is something you wish to attend. What is said in mediation is confidential and cannot be used against you if the complaint progresses to a trial or other legal form. The goal of mediation is to come to a solution that both parties can be satisfied with and agree on. Indicate whether you are willing to try mediation or not on the form. The goal of mediation is to come to some sort of compromise through teamwork between you and the respondent. So think hard about the things that you want. If you're not flexible about any of those things, maybe mediation is not for you. Step 8, Indigenous Peoples. This section asks whether or not you are Indigenous. If you are not, skip this step. If you are Indigenous and have more questions about the process and would like to speak with somebody at the tribunal, check the box. Step 9, Extra pages and evidence. This section only needs to be filled out if you have included extra pages. You can add up to 5 pages for both step 3 and step 4. Number each page you attach. Write the step you're responding to and name the respondent that it is about. As of now, you do not need to provide any evidence, unless it is to show why you applied late. Hold on to any potential evidence for later in the process. Step 10. Confirm information is true and accurate. Check the box and remember to keep a copy of your complaint form for your records. Step 11. Demographic information. This is a voluntary section where you can choose all of the categories that you fit into so that the tribunal can get an idea of who is attempting to access the process. Accommodations. If you require accommodations of any sort, you can send an additional page describing the specific accommodation you require or desire. This may be things like translation or interpretation. Privacy notice. It is important that you are aware that this form will become available to the other parties, including all information other than your demographic information. The complaint itself and any responses to the complaint can be seen publicly. Make sure that you are comfortable with this information being available before submitting. There's another option to request the tribunal limits the information it makes public, or ask for a publication ban by following the link at the bottom of the page. Protection from retaliation. The Human Rights Code protects you from retaliation for submitting this complaint. It includes, but is not limited to, eviction, firing or suspension, expelling, intimidation, or other similar harms. Thank you for watching. For more information about what happens next and what to expect to come of your complaint, view our other video, British Columbia Human Rights Tribunal, the What and How.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.